Okay, good afternoon for you bold and brave who've come through the blizzard. It's my great pleasure to introduce the speaker today. Sarah St.Vincent is a researcher and advocate on national security, surveillance, and domestic law enforcement for Human Rights Watch. Prior to that, she worked as a legal fellow on international human rights and surveillance at the Center for Democracy and Technology, where she promoted reforms to surveillance laws in the US, the UK, and the European Union. In addition to conducting policy and legal analysis, including in European Court of Human Rights cases, she led a national coalition to reform the US laws that underpin several large-scale communication surveillance programs. And prior to her time at CDT, Sarah was a Skadden Fellow at the Advice on Individual Rights in Europe Center in London, where she provided legal advice and representation to vulnerable immigrant women whose rights under EU law or the European Convention on Human Rights had been violated. She is a Wolverine. She has the JD from the law school here. Yay, go blue. And actually, almost as important to me, she's also a graduate of Swarthmore College, which I have an association with as well, where she earned a bachelor's degree in East Asian study. Oh, sorry. It doesn't say what you got your bachelor's degree in. Yeah, it was English and East Asian, and then she went on to another institution you probably heard of, Harvard, and got a master's degree, and she's a member of the New York Bar. So please join me in welcoming Sarah. Thanks, Sarah.
Just making sure this is, oh yeah, sounds good. Okay, well, thank you everyone for inviting me to give this talk. As Tom mentioned, I am a U of M alum, although I have to say it's my first time in this beautiful space, and it's really wonderful. As great as the law quad is, it's really good to see something quite as elegant as this. And thank you all for coming out on this very wintry day. This is very much the Ann Arbor I remember, as I've been telling everyone, so it's very nice to be back. It's also really great to see Data Privacy Day taking off and to be able to celebrate this with all of you. Because as I'm going to discuss with you, I think that this concept of privacy is tied to some core ideas that are really at the heart of democracy and that we should all care about very deeply. And so I'm really glad to have a chance to share this with you. It's also been great to meet some PhD students here whose thinking about these things is even more advanced than mine, and so that's really great. So as Tom just said, I work on mostly U.S. government surveillance at Human Rights Watch. I try to make sure that what the government does complies with our constitutional and human rights. And that's a bit like being an investigative journalist combined with someone who then pushes for change in Congress and is also doing advocacy in other fora that can have an influence on what the U.S. does, such as the European Union. And so I spend a lot of my day thinking about sort of specific surveillance issues, such as can police nationwide, and the answer is yes, get data about you from data brokers through systems such as, say, Accurant, that have every place you've ever lived, or every neighbor that you've had, every phone number you've had, and what's the consequence of that? That's my current area of research. I've also looked at things like, can the government, and again, the answer is yes, use a shadowy Reagan-era executive order to spy on people that the Defense Department thinks are quote-unquote homegrown violent extremists? And so I tend to wind up focusing on these specific things because, I want to publish something and do fact-finding. But all the while I'm doing that, I'm having this running monologue about really, deep thoughts about privacy and what privacy's role in society. And so I really love having the chance to come and speak and share those thoughts with you and maybe have a chance to hear what you think during the breaks as well. So once again, really wonderful to be here. And so as mentioned, I've now been working on surveillance issues, first at CDT and now at Human Rights Watch, for about 5 years. And in this work, I often encounter this idea, as stated first back in the 90s and oft repeated, that privacy is dead. We should all just get over it. I also frequently, in meetings with government officials and sometimes others, encounter this privacy versus security framing, that privacy and national security interests or law enforcement interests are somehow opposed, and then it's a zero-sum game. And of course, when you frame it that way, this kind of soft-sounding idea of privacy, which of course none of us have absolute privacy to begin with, it's always mutable, but when you frame it as privacy versus security, guess which one wins? And so I would like to posit that privacy is something different. To me, and I should hope to all of us, privacy is this idea that there is some sphere that is truly ours, whether that's body or property or information, and that no one gets to intrude on that without our consent, and I mean specific knowing consent, or without a very good reason in the government's case, where they've had sign-off from an independent party that says, yes, you can do this, meaning the judge, if we're in a warrant situation. And this is really central to equality and human dignity. So, for example, if I am entitled to order you to stand against a wall, and then I'm entitled to pat down your physical body, and you don't have the ability to object to that or demand that I have a good enough reason to do that, as happens with stop and frisk every day in this country, then you and I are not equal. Similarly, if I'm a company and I have the ability to just vacuum up all the information I want about you and profile you according to things like race or religion or political belief or gender, and again, you don't really have much say in that, and you can't get that data deleted or corrected or stop me from sharing it. We don't have an equal power relationship. There's a real imbalance there. We're not the kind of equally accountable bodies that we should be in a democracy. So Tom mentioned European Union law and specifically the General Data Protection Regulation. And of course that law is, not literally 1,000 pages long, but it's very long and complex. But I think sometimes what's more important than the specifics of the law is the animating principles behind it. Because history teaches us that any collection of personal information comes with inherent dangers. So for example, something as seemingly innocuous as census data fed into the internment of Japanese Americans on the West Coast during World War II. So even though having kind of even block-level census data may seem neutral, and it can, in a sense it is, any collection of data about us has the potential to be abused and needs to be subject to safeguards. Similarly, there's been reporting that IBM's data crunching technology fed into the Holocaust. And so I think part of what the GDPR gets at is that we're going to generate data. Companies and governments are going to have data, and there are going to be times when they have a legitimate reason to do that, but that there need to be really strong safeguards and accountability mechanisms in place. Again, why? Because we're supposed to be living in democracies, and we're not supposed to be able to have these bodies that can just know everything about us and intrude on us without any consequences or without sign-off from, again, some kind of judge-like body that says, okay, you have a good enough reason to do this. And as I was thinking about this talk, I was thinking back to one of my early days at Human Rights Watch. I was researching an issue called parallel construction. We put out a report last year called Dark Side. It's got a photo on the front of a sort of souvenir Drug Enforcement Agency medallion that has Darth Vader on it, and I'm not making this up. And the reason it's called Dark Side is the DEA has a sort of poorly understood special operations division whose job it is to get intelligence data from entities like the NSA and other intelligence agencies. And so I was researching this report about how the government conceals the fact that intelligence surveillance can make its way into perfectly ordinary criminal cases in a way that is not disclosed often to defendants or judges. And so I was talking to a former Justice Department official about intelligence surveillance and various programs that, again, may seem innocuous at first blush, but that can make their way into criminal cases and other contexts where they were never really anticipated to be. And this official just looked at me and he shook his head and he said, "Knowledge is power. Knowledge is power." And I know that's a cliche and we hear it a lot, but I really want us to think about the truth behind that statement, that knowledge is power. So, in honor of Data Privacy Day, I'm here to talk about privacy and power, as mentioned. And I'd like to start by positing that privacy is equality. And I mean that quite literally, for all those reasons that I just talked about. And so when you have the government say, well, privacy versus security, how does that sound if we say equality versus security? We're saying, like, wait a minute, those not only are not opposing goals, in fact, one could say that they're deeply linked, but equality is extremely important in the society. Or if someone says, privacy is dead, get over it, would we ever accept that equality is dead and we should just get over it? I don't think the answer is yes. So I'm going to briefly visit the history of the Constitution's Fourth Amendment and the human rights, the human right to privacy that's fed into. And I'll also touch on the ways that privacy and recognitions of privacy have helped facilitate recognitions of women's equality, the equality of racial minorities in this country, LGBT people, and what privacy means for the poor. So it's going to be a quick tour, and again, for some of you, this won't be news. But what I'd really like to challenge all of us to do is to think about, whatever issue you care about most, how does privacy, how does the maintenance of that sphere of the self, the integrity of that sphere, play into whatever it is that you're trying to uphold in whatever battles you fight? So moving on to the Fourth Amendment. So the Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And it goes on to say that the government can't get into your house or papers unless it has a warrant based on a good enough reason to believe that you specifically are breaking the law, and that the warrant has to be limited. The police can't just barge into your house and look for whatever they like. They have to be looking for evidence of that offense. So why do we have that in the United States? Why does the Fourth Amendment exist? And so again, when people say, privacy, and it sounds so sort of soft and mutable, the founders, the drafters of the Constitution, thought privacy was awfully darned important. And why did they think that? Well, back during the British colonial era, there was something called general warrants, or writs of assistance. And what those did was let the colonial authorities say, we think there's some sort of crime going on. And usually it was a threat to the status quo. It was a threat to the powers. It was a threat to the crown. So they were worried about things like seditious libel, basically saying unpleasant things about the monarchy, or customs violations, things that threaten their revenue. And so these general warrants or writs of assistance would say, there's a crime happening and the authorities have the ability to go look for evidence of that crime. And so the colonial authorities could basically just barge into people's houses, look through their papers, and again, we hear papers, think today data, and really be able to misuse that in a way that was intimidating, that suppressed free expression, and that was quite repressive for people who were living here under those colonial powers. And so many in the colonies deeply resented this. It's a significant part of what led to the American Revolution. And in 1761, there was a Boston attorney named James Otis who stood up and gave what turned out to be a very influential speech in a case. And he said, everyone with this writ may be a tyrant, someone who could, quote, reign secure in his petty tyranny and spread terror and desolation around him, and generally, quote, lord it over us, while ordinary people without such powers became, quote, the servants of servants. So for Otis, the ability to preserve a sphere of privacy in the home, unless, again, there was good enough reason for a judge to believe that someone had committed a specific crime, was really crucial to preventing tyranny, right? And preserving those values that should exist in a democratic society, the balance of power between the government and the governed. What Otis was pointing out was that when you have insufficient checks on that ability to invade privacy, that ability to get into your house, your papers, again, your data, is something that really facilitates abuse, and that we need to have checks to prevent that. But what I think is one of the most telling bits of this language is this language about the servants of servants. Surveillance creates and reinforces hierarchies. It creates and reinforces classes. There are those who do the watching, and there are those who are watched, and sometimes that overlaps, but we really need to think about the ways that surveillance and data collection segment society between the more and less powerful, the more and less accountable. So the Fourth Amendment inserts a judge into that process and says the government just doesn't get to do whatever it likes. You need an independent, neutral third party, in theory, the judge, even though many judges may in practice be deferential to the government just doesn't get to do whatever it likes. We need something to restore that equilibrium that we should have in a democracy between the government and the people that it's ruling over. So the Fourth Amendment later provided a starting point for the drafting of the human right to privacy that then shows up in the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights that the U.S. is a party to. So not only is privacy a human right, it applies in this country. You can't go into court and enforce that for reasons that are kind of technical, involve how international law works, but there's absolutely a human right to privacy. And what I think is really fascinating is that in the International Covenant on Civil and Political Rights, and also in the European Convention, and I think the American Convention on Human Rights as well, there's the right to privacy and the right to family life and the right to home and correspondence. Those are the same right. So in European Court of Human Rights jurisprudence, immigration questions, the questions of whether someone should be allowed to stay in a country with their family, even if there's now something wrong with their immigration status, falls into the same right as the question of whether the government should be able to surveil you or whether your workplace should be able to surveil you. There's this recognition that there's some sphere of the self, a sphere that is ours, the things that make us human, our thoughts, our beliefs, the beginnings of our free speech, forming relationships with others, whether it's professionally or with family, the ability to have a home, to have a family, correspondence, again, this kind of cultivating relationships and thoughts with others. We see that privacy really is this something very core about us. And it's also a gateway for other rights, as some UN experts have said. If you don't have that privacy to form your thoughts and opinions, you don't necessarily then get to have your freedom of religion. Freedom of speech becomes a lot harder. Privacy becomes this gateway to so many of the other human rights and constitutional rights, like the First Amendment, that are so deeply important to us. And today, so many of us, of course, are continuing to fight for the warrant requirement, that balancing of power. And for me, as someone who works a lot on intelligence surveillance, think about this all the time. Why is it that the government fights so hard against a requirement that the judge should need to be able to issue a warrant, to know what's going on, to restrict what's going on? Why is that such a problem for so many in the government? But also, of course, we have these very powerful companies, and we had this reference earlier to the possibility of the integration of Facebook and Instagram and WhatsApp. We have these ever more powerful data collecting companies where we don't yet have a GDPR. We don't yet have the equivalent of a warrant requirement, something that can help to restore that balance and prevent serious abuses of us. And I think it's really key for Congress to start taking action and all of us to think about, what should this control look like? But I think we should start from the assumption that some sort of control, some sort of check has got to be there. So I'd like to move on briefly to privacy and race. And I think in the US we can see all through history that surveillance has been deeply tied to race and gender. So there's a wonderful book out there called Dark Matters by Simone Brown, who's a scholar, I think, at the University of Texas. And it's about the use of surveillance during the era of slavery and then surveillance of African Americans moving forward. And she documents a New York City law, which was the Lantern Law, which said at a certain period of New York's history that slaves who were out at night had to carry a lantern to illuminate themselves so they would always be visible. And she locates this, she defines this as an early kind of racialized surveillance. She also, I know this is disturbing, but I think it's insightful, the practice of branding she sees as an early kind of biometric surveillance. So we can see how some of these things have a really troubling history, and I think that's really worth thinking about. And of course, as we move forward in US history through the 60s and 70s, we see rights violating surveillance by the Federal Bureau of Investigation, the Central Intelligence Agency, the National Security Agency, during that period that was meant to keep the status quo as it was. And so they were surveilling civil rights activists such as Martin Luther King, the American Indian movement, the women's rights movement, anti-war demonstrators. So surveillance becomes this tool of control, but I also would like us to think about, we know that the government watches dissenters, right? We know that the government watches minorities disproportionately. And so I think that sometimes surveillance is not only a product of the message, it's not only a product of racist attitudes or fear of the other. Sometimes surveillance is the message, right? We start fearing the other because we know they're being watched, and we start to think maybe there is something more dangerous about them. Maybe there's something more criminal about them. And so surveillance becomes a sort of feedback loop, and I really want us to think again about the ways that it not only reflects these prejudices, these hierarchies, but the way that it operates to reinforce them. And to reinforce biases in society. Meanwhile, and this is something I didn't learn in constitutional law, but I'm going to share it with you now. Well into the 20th century, US courts wrestled with the question of whether women legally exist. So the US inherited from Britain the notion of coverture, which was especially for married women that you had no legal existence independent of your husband. You didn't own your own property, and your body wasn't really yours. So, for example, in a domestic violence case or a case of marital rape, you had no legal rights. You couldn't defend yourself against an assault in court because there was nothing that was truly yours. You were subsumed into your husband. And so the Supreme Court in 1910 points out that it's only when laws began to change that a married woman became empowered to control and dispose of her own property, free from the constraint of her husband, and sue for trespass upon her rights and property, and to protect the security of her person against the wrongs and assaults of others. So in other words, this recognition of women's privacy and women's equality were one and the same thing. We were recognized as people when we were recognized as having the ability to own things, to have land and keep people off of it, to have bodies that we could say other people needed not to do things to, that we could assert this right over our things, our bodies, our land, ourselves. And so without privacy, we were, legally speaking, virtually nothing. And we certainly weren't men's peers when it came to our ability to go before the court to assert our humanity, to assert our rights that so many others took for granted under the Constitution before that. And it's significant in this respect that the U.S. Supreme Court has located abortion rights in the right to privacy. So regardless of what you think about that subject, the court has found that this ability of pregnant women to exclude the state from their bodies in this respect is tied to the right to privacy. Now, there are many people who think that that decision, Roe versus Wade, should have been premised more explicitly on equality. But again, we can see privacy functioning as equality, that this is how we're recognizing someone's rights to control their own body, to control their own decisions and themselves. So again, privacy as equality. And so when we come to LGBT people, we see much the same thing. And I want to pause here and acknowledge that, of course, the idea of intersectionality is really relevant here, right? Like, many people are both women and people of color, many people are both LGBT and people of color. And so some people in some communities can experience multiple layers of surveillance and therefore multiple kinds of being disadvantaged, controlled, classed, and disempowered in society. So again, we should start by thinking about the inequality of people during the time when states in the United States asserted the right to look into the bedroom and decide, and investigate what consenting adults were doing and decide whether that was lawful or not. And so in 1986, in Bowers versus Hardwick, the U.S. Supreme Court gets this question of, can states have anti-sodomy laws? Can they prohibit what a same-sex couple does in the bedroom consentingly? And the court in 1986 looks at that as a question of, is there a right to same-sex sexual activity? And the court says, no, that's nowhere in the Constitution, so of course not. But society and societal views evolve. And in 2003, in Lawrence versus Texas, the court says, oh, wait, this isn't about is there a right to a certain kind of sex, it's about privacy. And of course, people who are LGBT also have privacy rights, and therefore they're entitled to do in the bedroom what any consenting adult can do. And so this recognition of LGBT people's equality came through a recognition of their privacy. And so again, we see the connections here. And it's really interesting to me that under European Court of Human Rights jurisprudence, the right of transgender people to identify as their chosen gender is also located in the right to privacy. The idea is that the state doesn't get to decide what gender you are, you do. Again, privacy, selfhood, identity. And so, because I'm sure this was not enough yet, right? I'm going to turn to the surveillance of the poor. It's an area that I think really doesn't often receive enough consideration when we talk about privacy. And so when we think back to 1984, I'm assuming most people, raise your hand if you've read 1984. Right? Yeah, most of us have. I think the things that tend to stand out in our minds when we think about 1984 are things like the Day of Rage and the surveillance and the Big Brother posters and the things that are kind of big and intimidating. And what we tend to overlook is the thing that George Orwell establishes in the very first paragraphs of the book, which is that Winston Smith, our protagonist, is desperately poor. He is sick, he has no hot water, he's walking around with very few clothes, he struggles to find soap, he's hungry. And so what we see in that book is that the goal of the state is not just the control of people's political views, it's the ability to exploit them, right? The surveillance is keeping people down so they can be made to labor but without much gain. And various forms of monitoring today do similar things. There are scholars like Virginia Eubanks who have documented how people have to answer really intrusive questions, for example, to get welfare benefits. And so this does two things. One is, again, it puts people in this really subordinate position. They get asked questions, they're forced to take, for example, urine tests for drugs. We're asked, how many pregnancies have you had? Are you living with a partner now? How many sex partners have you had? I'm trying to think some other examples of this. Health conditions that you have. Things that you really don't feel comfortable divulging, but that the state or your locality can make you divulge, just in order to get a baseline level of support. And in turn, this facilitates victim blaming, right? Because then you can turn around and say, well, you took drugs. You have someone living with you. You didn't fill in the right form. You moved in with somebody without telling us, and all these things that let us then put blame back on the people who are seeking help. And again, this winds up reinforcing reinforcing classes because it sends the message that people are poor because of something about them, that they're poor because they deserve it, and that they deserve not our assistance but our scrutiny. And I guess the last remark I would make on that point is about the digital divide. Have people in here seen I, Daniel Blake? Any nods? Okay, really good movie from the UK, and this is actually very much the kind of thing I used to do when I was fresh out of law school and working in the United Kingdom and trying to help people claim social welfare benefits. There are these painful scenes where Daniel Blake, the character, an older man, very ill, had been in work but has a heart condition and isn't able to work anymore, is trying to claim benefits and doesn't know how to operate a computer. He's just never done it. He's always worked with his hands. And here he is, forced in this really humiliating position by the Department for Work and Pensions in this scenario, where he's forced to go online to claim benefits. And you think about the ways just the digital divide operates to make things harder for those on the bottom, to be able to assert their rights and claim things that can help them. And so we can think of, it's easy to see the digital divide when it's kind of literal in that way, can or can you not use a computer. We can also think about it with the tech companies. Again, who gets our data, who has control over it, who has access to it. And this idea that it's on us somehow to set our privacy settings a certain way, to give or not give the companies a certain kind of data, rather than the responsibility being on the companies to be not only transparent about what they do, but give meaningful control back to us, and for our data to be valued in a way that really winds up benefiting us, and I don't just mean through quote-unquote more relevant ads. So I'd like to leave you with the observation once again that privacy intrusions both create and reinforce power disparities, and I think we all have the job of really thinking about that and integrating it into how we regard a variety of issues that we care about. And so, for example, I know there's a panel that's going to talk about what's public and private in the digital age. And so the U.S. Supreme Court has been telling us for decades that when it comes to government surveillance, we lose our privacy interest in something as soon as we've told somebody else about it, or as soon as we've perhaps said it publicly. And so I want to say, what if we didn't ask what's public and what's private? What if we asked, what's an essential feature of the ability to maintain ourselves, to form relationships, to prevent dangerous disparities of power? What if we asked that question instead? So thanks again for this opportunity to speak to you and for listening. I'd love to speak with you at the break if you're interested. And again, thank you for having me. I'm glad to be here. I hope this is useful.